This all started with a 2019 Colorado law banning what some people called conversion therapy for minors. From the opinion we read, in 2019, Colorado adopted a law prohibiting licensed counselors from engaging in, quote, conversion therapy, close quote, with minors, defining the term to include any practice or treatment that attempts to change an individual's sexual orientation or gender identity, as well as any effort to change behaviors or gender expression, or to eliminate or reduce sexual or romantic attraction toward individuals of the same sex. Now, Colorado defines conversion therapy as any attempt to change or convert a person's behavior, gender expression, or sexual attraction, but only to those of the same sex and so-called transgender. This is a one-sided and biased law. Yet the law explicitly allows counselors to provide acceptance, support, and understanding for identity exploration and development, and to assist persons undergoing gender transition. So Colorado thinks it's okay to encourage such attraction, but not to discourage it. Now, part of the push behind these conversion therapy bans has more to do with the imagery rather than the actual techniques. The term conversion therapy may evoke physical techniques such as electric shock therapy aimed at changing an individual's sexual orientation or gender identity. Now, Colorado's law doesn't simply forbid shock therapy or any other therapy that harms the individual. The law forbids as well any effort to change behaviors or gender expression or to eliminate or reduce sexual or romantic attraction or feelings toward individuals of the same sex. At the same time, the law explicitly allows counselors to engage in practices that provide acceptance, support, and understanding for the facilitation of an individual's identity exploration and development. Likewise, the law allows counselors to provide assistance to a person undergoing gender transition. So, Colorado doesn't have an issue with conversion therapy, only in attempts to assist those who are not comfortable with their homosexual or transgender feelings. In other words, only those that challenge the politically correct idea that homosexuality and transgenderism are normal. Ms. Childs filed suit in federal court seeking a preliminary injunction raising a First Amendment challenge to the law as it applied to her talk therapy. Now, Ms. Childs claims that the Colorado law violates her rights protected by the First Amendment. I will discuss the First Amendment issue in another section where I will show this is actually a 14th Amendment violation. However, the question the court was asked specified a violation of the First Amendment. The question before us is a narrow one. Ms. Childs does not question that Colorado's law banning conversion therapy has some constitutionally sound applications. She does not take issue with the state's effort to prohibit what she herself calls long-abandoned adverse physical interventions. Instead, Ms. Childs stresses that she provides only talk therapy, employing no physical techniques or medications. Ms. Childs agrees some form of conversion therapy, namely those with adverse physical interventions, can be banned. However, she does not employ such physical techniques or medication, yet Colorado's law still applies to her. Yet she agrees Colorado's law still applies to her, prescribing what she may say in voluntary counseling conversations with her clients. And because that application of the law strikes at the heart of First Amendment protections for free speech, she contends it warrants considerably more searching scrutiny than the rational basis review the 10th Circuit applied in this case, or the immediate scrutiny review some other lower courts have employed in cases like hers. We agree. I agree that Colorado's law abridges Ms. Childs' freedom of speech and much, much more. However, it does not and cannot violate the First Amendment.